in the order itself.
That's what I was just going to tell you. We're on the same wavelength. In Maryland, it's 10 days, but 5 days you have to give the intent that you're going to challenge it.
Or you waive it.
Or you waive it, and guess what? The associate judge will tell them about the 10 days, but they don't tell them about 5 days.
So these judges, who the Supreme Court said are supposed to be a fortress for the protection of our rights, and they said this in a child custody modification case, where ironically, the only time ever they've applied the First Amendment free speech to a child custody modification case.
That's why I was saying my little lead in. I was saying the people that we expect to be the protection are really the biggest part of the problem.
Because they've been given unbridled power, unlimited authority. We know that power corrupts. We know that absolute power corrupts absolutely. These legislators are giving these district judges unlimited power. That's what best interest of the child means. Whatever you want, Judge. Your viewpoint, your opinion is all that matters. That's called unbridled power.
Yeah.
And this makes them drunk.
Especially when best interest of the child is not defined.
It's undefinable.
Yeah.
Probably can't be.
Oh, you know
What's the best NFL football team?
Because we do vary from person to person.
Yeah, it's an opinion. It is a viewpoint. And worse, it's a viewpoint on matters of conscience in child rearing. Matters of conscience are supposed to be absolute rights. But these judges are making decisions based on their viewpoint regarding matters of conscience.
And the Supreme Court says your conscience cannot be wrong. So here's a judge. They're supposed to judge you, protect your rights, but also judge the facts of the case, right? So they're judging your conscience. And the Supreme Court says you're not supposed to do that.
And it gets worse than that. Since it's not written down, when do they determine what's in the best interest of the child? It's after you've done whatever they've complained you've done about.
So you don't even know.
That's called ex post facto.
Yeah, you don't even know.
So they make up the rules after you've done whatever they're accusing you of having done.
I made my kid rake the leaves. I didn't know that was going to be held against me, right?
Exactly.
That's abuse.
That's what I was trying to tell you earlier. You're like,
Well, I was really abused then. Every time I went to pick blackberries and
that's what I was trying to
rake
tell
leaves and.
Absolutely.
We had to do
Is there a statute of limitation? I think you can go back and sue those family members that made you.
Everyone in the neighborhood did it.
You're damaged.
We go out in the woods and early in the morning, pick blackberries and pick berries and come out the woods a certain way, and on the way home, try to sell them on the way home.
Yeah.
When I was a kid, pecan season, the pecan trees everywhere where I grew up. And we would go and pick those and go sell them.
And sell them. That's what you do.
Yeah.
But you can't do that anymore. These judges put the children in charge. The children are raising their parents now. The children are making the decisions, because you go into custody battle, you're terrified of your teenage child, because these teenagers, they hit these hormonal stages, they want to do things. And they manipulate the parents, and then the judges go along with it. We're in Texas. These are supposed to be conservative judges with family values and understand that you've got to direct these children and raise these children. No, they put these children in charge. They turn into socialists faster in family law than anywhere else, even in Texas.
Now I wanted to ask you guys about, I know in Arizona they've had shared parenting for a while, several years. I was wondering if there were any studies done about that.
They did. And Fabricius, Fabricius, he's the one that actually had his hand, a large part of the reason that judges were educated so well in Arizona about starting off at equal was because of Fabricius, Professor Fabricius. And so they have a parenting law that actually a lot of it looks similar to what state of Texas has, but the difference is that theirs says it's maximum, right? And the difference is the judges were already thinking and supporting equal parenting before the law got passed. So their law doesn't actually say the words equal. Just recently, I believe it was June of last year, 2018. Just recently, their appellate courts actually interpreted their statute as the presumption of equal, even though their statute doesn't say presumption of equal. And let me tell you why Fabricius says it doesn't say that. Because a lot of states right now are pushing for presumption of equal, put those words in your bill, and we actually published that no, that's not the right starting point, and he was correct, because yes, the judge's discretion is limited, but it's limited by the Constitution already. You start putting those presumptions in there, then people can, then the legislators start interpreting what's rebuttable, whereas you want to kind of leave that part alone because the Constitution is actually stronger usually than what most legislators put in there, right?
And what they'll say about this is they'll say the Equal Protection Clause doesn't guarantee you equality as a parent. It doesn't demand that you have equal parenting time. And ironically, they're absolutely right. That's not what the Equal Protection Clause does. But your substantive rights do, because we spoke a minute ago about strict scrutiny, right? Well, one of the elements of strict scrutiny is an ends-means test in how they apply the restriction, and it has to be least restrictive.
Right.
That means they can't restrict an individual's rights more than absolutely necessary to meet their agenda.
So if you put
whatever
rebuttable,
if it's legitimate.
right? So if you put rebuttable in there, what do they make it? What do they consider that can be used to rebut it?
What is
Best
sufficient
interest
to-
factors, right? So point of view discrimination, and so
this is-
they weaken that right when they don't understand the language that they're pushing to be put in those bills, and so you have to be very cautious with that. And so Fabricius, he was pretty smart about that. He's like, look, let's educate the judges on where things should start. Now, he of course educates based on the mental health perspective.
Well, judges and lawyers alike are invested with a lot of trust. Trust is at the heart of it, and it seems as if that trust has been in large part misplaced.
Absolutely.
Well, it's been eroded.
Misused or abused or something.
I think it's
They
been
violated
eroded.
our trust, and they violated
Yeah.
their oath to the Constitution, their Article 6 oath, because they're supposed to put the United States Constitution as the supreme law of the land, and any law that violates that is no law at all.
Yeah,
But they
anytime
don't do that in
anytime
family
a
law.
parent goes into court and they feel like the legal system's abusing them worse than they felt they were abused in their relationship, you've eroded that trust and you have abused that authority that the American people exercised their power to put you in that position.
And you've taken,
you have
taken their money in the
advantage.
process.
You've
Exactly.
taken advantage
that's
of them.
just-
And the children.
That's
And
just
that's
right.
the most
And
shameful.
The children
They've
grow up
taken their money
learning
and
not to trust
yeah.
these judges because
Yeah.
the judge stole a parent from them from no reason whatsoever. And they know that parent's a good parent because most kids, as they grow into adults, rekindle relationships that these courts have destroyed with
And
their parents.
Fabricius points
And
that
they
out.
know these judges did this for no reason whatsoever.
You know, the studies have shown that children, actually, part of the reason they have more difficulty adjusting to divorce is because a parent gets taken out of their life. And so they actually adjust better. Even if the parents are in conflict with each other, they adjust much better if they have that, they call it frequent and continuing time
They
here
still
in
have that
Texas.
access and continuing bond
Right,
with both parents.
right, but they're showing that it's not just frequent and continuing, it's that equalness, it's that hey,
Equal authority as
Yes,
the parents.
equal
That's one
authority.
thing child support does is it changes the authority structure.
Right.
The person with the money has the authority, especially in the teenage years.
so they
Yeah.
still lose a parent even if they're like in Texas, even in the expanded standard possession order, because that parent who's ordered to pay child support does not have the same authority that the other
Now, you
parent
know what I
has.
don't want to get lost in our discussion here is the person that's being harmed most are the children.
Yes, their fundamental rights are violated in every
they're-
child custody case.
They're at the mercy of strangers.
Exactly.
They are, but,
Now, here's
but they
the interesting
protect
thing.
their
Versus
rights. They protect
strangers
their-
who may not even care.
But they protect their rights in the wrong way because when they hear that, they go, oh, we need to put that the child's voice can be heard and the judge can talk to them in private. And you know, just this year, a retired judge testified to the legislature, and you know what she said? She said, I hated that law. Those were her exact
Well,
words. I hated that law.
the Texas
but
law
she
does
hated
not-
it for a different reason because she said she couldn't do anything when the child would say, make it stop. when she interpreted make it stop, like the child would come to them and say, just make all this stop, because the parents are fighting over that control, that superiority. If they had treated this right and protected the child.
Which I believe is fed into them by the lawyer.
Right.
Well, one interesting thing
Because the more litigious it is, the more conflict, the more money.
Yeah, and
that's just wrong. To me, that's just wrong.
But the judges, they're put in this position where they're thinking now, oh, because the parents are fighting is what the child's asking me to stop. But really, what the child just doesn't know how to articulate is that this whole process has made my parents mad. Like crazy. You need to put an end to this madness.
Process, to the government caused chaos, not my parents.
Yes.
So two things real quick. One thing, that law in Texas that allows judges to take child in chambers does not authorize them to do it in private. It does not authorize them to exclude anybody. It does not authorize them to cancel out cross-examination. That child is giving testimony. Cross-examination and confrontation are essential, and these judges are violating that in the most fundamental way when they take that child in there alone. But back to the child's rights. The court has said, the Supreme Court said, one of the most important rights we have is the right to be left alone by the government. The concept of privacy, right? Now think about this from a kid's perspective.
That's
You're a minor
that's
child.
freedom.
Exactly,
That's
it's freedom.
freedom.
So from a child's perspective, how do you exercise your right to be left alone, free from unwanted government interference in your life? You depend on your two fit parents to protect you from the government. Now, what happens the moment your parents get divorced?
All it takes is one parent with a messed up agenda to screw up everything.
The government strips this child's right to be free from unwarranted government interference in their life, and the government takes over this child's life.
And then they restrict the parents from explaining to the child. So guess what the child does? Fills in their mind, that other parent who I don't see very much, they must not love me.
Oh yeah, and it's
They
bad
must not
because
really want to be with me.
in Denton County,
So-
they have standing orders. In those standing orders are prior restraints on free speech, telling the parents that what they can and cannot talk to with their children. Now in Texas, prior restraints on free speech are absolutely unconstitutional. They're presumed unconstitutional.
But in family
and
law-
the state has to prove that they meet the burden before they can impose them.
Yeah.
But in Denton County, for well over 10 years, they just updated them last month, right? They have prior restraints on free speech.
Standing orders.
So they can't even meet the burden that the Texas Supreme Court said applies because that requires case-specific evidence to justify your orders. Standing orders apply to everybody the minute they file the petition.
Right.
So a
And
standing
therefore
order,
they fail.
A standing order for your viewers, what that means is it's a restraining order that they put in place so that they can't move they can't move their money around. It's intended to keep everything exactly the way it is at the time that it's filed, but they go further and they start putting restrictions on you, so they infringe your rights immediately.
And what they're saying with this
Without a
standing
hearing.
order, when
Yeah,
they violate
hearing.
your free speech rights, what they're saying is that your rights, your constitutional right to free speech, has no place in my court because I'm sitting here saying you cannot speak.
They're perceiving
It's that simple. These Denton County courts, every single one of the judges, the district court judges in Denton County sign this thing, and they renew it regularly. One of those judges claimed to be a constitutional attorney before he was a judge. One we know very well.
I know we're laughing, but it's actually really sad and scary. So children, they actually would do so much better if they wanted to put a standing order in place. It should be both of you have these equal rights immediately, and this child doesn't lose either one of you. And you know what? They wouldn't need to be restricting the parents much because they wouldn't have to fear that they're going to be stripped out of the child's life. And you know what? The child wouldn't have to worry
These courts say
about losing that support from each parent.
So they're creating conflict.
Right, they absolutely create conflict.
Instead of
but not conflict.
ending it or trying to resolve it.
Not conflict in a legal sense, because the conflict in a legal sense is that we both have full and equal constitutional rights to these children, and we're conflicted over how we can exercise that without stepping on each other's toes. That's the conflict. That's what gets you into the court and gives you Article 3 standing, which Article 3 doesn't apply to the states, but Texas has the same standing rules that the federal government has. But instead of that conflict, they say the conflict is what's best for the child. The child is not a party to the suit. The child doesn't even have standing to be a party to the suit, and yet we are making orders based on what we think is best for someone who is not a party to the suit.
What drove me insane in my case? Keep the child out of the middle. Yet all these policies put them in.
Yeah, every one of these force the children in the middle.
I'm sitting here thinking, I'm trying to keep my kid out of the middle, just protect our rights, darn it.
And they say these children are entitled to stability. They've created this right out of thin air for these children, right? But the first thing they do is destabilize these children.
Make it unstable.
Right. Imagine if the standing order said you each are full and equal parents, you each will have full and equal custody and possession of your children. The only thing we're going to decide here is how you exercise that, whether it's week on, week off, every other day or every other weekend like I did, or like one of the appellate court judges we know here in Texas. He had the standard possession order, but it flipped each month. Right? So 1 month he was the primary under the standard, the next month she was. Right? So that was equal. There are all kinds of ways to do this where the children will know you have both parents. You will have both parents fully and equally in your life. The only thing we have to figure out is when you're going to see each parent and when they're going to have the primary say over your life. And you know what? Most of these things parents argue about don't matter. Who cares what time the child goes to bed? So they're upset. So they're a little bit stressed. Children go through stress. It helps form character, right? The only thing that matters is what school the child's going to go to.
Okay, but I have an argument about the stress thing, because if it matters to the parent, what they have to do is they have to realize that they don't get to control the other parent, and that it's not going to destroy their child. Now, there are some children that have very, very extra sensitivities and emotional things, right? And you know what? The parents get to try to work through that first, even if they're in disagreement, before the government steps in. And so some people will argue, but I want to protect this child from harm. But the problem is, as you see, when you ask the government to come in and use a crystal ball and try to protect the future, they're going to harm you and your child
and that's
before
what the
harm
judge's
ever
guide says,
starts
actually.
or
the
happens.
Judge's guide that they follow, that's written for them, says crystal ball in it, that they're looking into the future. Right. Now, go back to the standing order. What's the judicial authority? The judicial authority is not to resolve conflicts in the future. Right? That's legislative, executive authority. That's not judicial power. They are not even exercising judicial power. They are creating forward-looking policies and calling them judicial orders.
So now you have violation of the separation of powers on top of everything else. So what parent?
Maybe that's where the God complex comes from.
Okay, so Mike, what parent can worry about all this stuff? They just want to live their life. Their relationship didn't work out, for God's sake.
They're in conflict. They're fighting, right? But here's the First Amendment protects what? Not your right to agree with other people. Your right to disagree.
Yeah.
Now, your rights as parents are not 14th Amendment rights. They're First Amendment rights. Your right as a parent is established and protected by the Constitution the moment you do what? You form the parent-child relationship or the association. Right? It is a First Amendment association right. It is a free speech right because you have a right and a duty established by the Supreme Court to educate your child on your own moral, religious, and civic values.
Now, the Attorney General,
thing.
Denies that it's protected by the First Amendment. You know why? Because they can use lowered standards, because the 14th Amendment, they haven't really settled. I think on the Supreme Court there's gray area, right? Fuzzy area about how strict they need to be with the protections. They use the word liberty a lot because, again, that's not as well litigated as First Amendment.
First Amendment's crystal clear, but in Texas we have something just as strong. It's called the Texas Religious Freedom Restoration Act, right? And it establishes strict scrutiny for substantial burdens on religious freedom. Now, if you have a right and a duty to educate your child on your own religious beliefs, and your time with your child is less than the other parents, is that not a substantial burden on your religious freedom?
Yeah, judges are picking religions.
We have that in the Supreme Court right now of Texas. The Supreme Court's being asked to decide because the appellate courts and the district courts say no. TRFRA, the Texas Religious Freedom Restoration Act, does not apply to parents in divorce. but that act also says it includes every statute in the code, all the code, unless it's specifically exempted. Family code is not exempted in any way from the Religious
So you
Freedom
know
Restoration
this is
Act.
maddening for attorneys who do look at the words and they actually, you were taught in law school, words meant something, right?
Actually,
Yeah.
And these substantive guarantees provided by the Religious Freedom Restoration Act are non-discretionary. Judges have no discretion whatsoever not to apply these protections. None.
But they ignore it.
And they do it anyway.
yeah.
Right? And they're protected from suit. It's very hard to sue judges. It's very hard to do this. So by having these judges make these policy decisions, which is what these are, they've protected these policy decisions from proper civil rights suits because judges
I hope
can't
I
be
don't get in
sued.
trouble for this one, but
Uh-oh.
there was some. They had a bunch of judges in Harris County,
Yeah, they got
We're
sued.
familiar.
and they were Republicans.
Yeah.
Mm-hmm.
And I am a card-carrying Republican, 3-time convention delegate.
What was it? 93 judges replaced?
Sat on the convention committee, and they wiped out the whole
All of them.
courthouse.
Now, here-
You know, we lost
They
it,
wiped
though.
out the whole courthouse.
but you know what? The same
Civil, family, and criminal.
Okay,
the
but here,
same standards the Fifth Circuit applied to those judges in that context, which was a bonds context, and whether they were denying these judges were denying bonds based on their inability to pay. That context, you can sue judges.
But
We
before-
cited that
before you
case
move on
and
to that-
applied it in a Fifth Circuit
Before
appeal,
you move on to
and they
that,
said no.
I want to make a comment because, Mike, you're right. And
Although I'm a card-carrying Republican, I'm glad that it happened, and because something had to happen.
but
Except
here's
they don't
the
do it in
problem.
family law. Even the federal courts, the Fifth Circuit said those same rules don't apply in family law.
but
You can't bring that
but here's
case
the
in family
problem.
law.
I agree. So, you know, the people spoke and they needed to be heard, and they were. However,
Loud
the
and clear.
same bad systems are in place and the same bad policies.
Right.
You just-
So they're just
So I
gonna.
spent
they're
25 years in corporate
so
America
what-
building systems and consulting on building systems. It doesn't matter what kind of people you put. You can put the best person in the world in a bad system, and that bad system is going to just erode that person's ability to fight because they will be spending every minute fighting against this system. Sooner or later, they're either going to quit, they're going to go insane, or they're going to leave and go
So what
somewhere
happens
else.
is
Bad
good
people
judges
just follow
leave.
the system.
Yeah, the good ones leave when they realize. Like, there was which judge?
An old saying say you can't
said-
fight City Hall.
Oh yeah, it's very hard. You can do it, but it's incredibly hard.
One of the judges that you and I have talked about a lot from Texas, he retired recently because he said, the judges, you know, they wouldn't agree with me anymore. And so he left because any judge that's trying to actually say, hey, look, it's time that we get rid of these bad precedents that we set. There's been lots of times we've gotten rid of bad precedents, Jim Crow laws, slavery, right? So
Yeah.
now we need to change the bad precedents in family law, and every time one of the judges tries to do it, they get frustrated because there are so many of them that they have to fight against.
Yeah, and if you're going to actually say that, you know what, these courts are doing the wrong thing and they're violating our fundamental rights, well, you have to go back and look at how many of these judges have been family law judges, how many of them that have done this for 20, 30 years and sat on appellate cases where they've upheld all this. They all have to admit they're wrong, and they're not going to do it. And you know what? The federal courts won't let us get in because even though family associations are the highest protected association rights, the federal courts will not let you bring suit in a federal court on a family matter.
Right.
They block it out, even though it's supposed to be the...
They've left that to the states.
Yeah.
But
Supposed to.
yeah, but that's not what the Supreme Court said
Right.
has to be done. The Supreme Court just said you can't issue custody decrees and divorces, right? It didn't say you can't determine what the constitutional rights
Otherwise,
apply in that situation.
how did we get Leving versus Virginia? How did we get the same-sex marriage opinion? And how did we get Troxel and Stanley?
So
How
these-
did we get all those if it's all left to the states?
So these
It's just
parents,
that they didn't go through the federal route,
Right.
and it's a long shot to be heard, and it's very expensive. So most parents, even though there's lots of constitutional errors and mistakes happening, they can't afford to be heard. They lose their kids because they can't afford to fight.
Right.
and we've helped parents who had so much between child support, and this wasn't Texas, alimony, and orders to pay the other side's attorney's fees,
Yeah.
they were ordered to pay more every month than they had ever made in their best month working full overtime.
And you know
And
why?
what's
So
this
they don't
parent to
fight.
do?
You know what they tell them? Stop fighting.
Yeah.
That's what we're trying to tell you with
And
these
what
orders.
they're saying, you come in here fight, we're going to destroy you.
Yeah.
And that's what they do. They destroy these parents emotionally, psychically, financially. They can't fight anymore. Very, very few parents.
We need
we've
a
dealt with-
federal court to come in and put a special master over the family law process like they did for the foster care system
Absolutely.
until they correct these constitutional violations. That's what needs to happen.
But first, the federal courts have to let us in
Yeah.
and let us bring these suits against judges. They let us do it if it's a probation violation or a parole, or not a parole, if it's a bail bonds violation. We can sue the judges in the Fifth Circuit. But these same judges, exact same judges, by the way, when they preside over a family law case, we can't sue them. The Fifth Circuit says, oh no, these judges are protected, you can't sue them.
Yeah.
That's schizophrenic. Have it one way or the other, Fifth Circuit. You can't have it both ways. I'm sorry. I'll tell them how it is. I don't care. Fifth Circuit has a lot of great opinions, and generally it's a great court. But when it comes to family law, they lose their minds.
Yeah.
All of these judges, all of these courts, you say family law, the child, they lose their freaking minds.
Yeah.
I'm sorry. I'm sorry we're on TV, but they do. They lose their minds.
Don't apologize. If you're not lying, don't apologize.
We
It's like
get
everything they
passionate
learned in
here.
law school, which is not that much about the Constitution, but everything they've learned about the Constitution goes right out the window and, oh, the kids, best interest, we don't need all those rules, procedures, due process, substantive
Yep.
rights.
Those
They don't
rules-
apply here.
They say those rules create so much red tape that we're not able to protect the child or families. They're
yeah.
not protecting them by completely eroding the protections that our founding fathers put in place that our soldiers and ancestors died for. I was just up at the Capitol building today and I recorded that Confederate statue with the Abraham on the top there, and it said they died for to protect our rights. So if they died to protect those, why are we eroding them
And if
now?
our-
That's such a
and if our
that's such a
family association
disrespectful
rights
disgrace.
Are our most precious rights in this country. Why are they not being protected? Why are the federal courts abdicating their jurisdiction and their responsibility to protect these rights? I don't understand it.
Well, I don't understand why they can't undertake to try to do something to address the needs of children.
Most people
To
would
me,
say
That's
follow
what they
the
say
money.
they're doing.
To me,
By
the needs of children should be paramount.
They're trading
The
they're
rights of the
trading
children
the
should be
needs.
paramount.
They're trading they're trading the children for their federal dollars. If the state of Texas is number one in the amount of child support that they order,
they brag
in
about
the
it.
amount of
They
child
brag
support
about
they
it.
collect, then they are number one in dependency on the federal government.
This
So-
is conservative Texas, number one dependence in the
Yeah.
federal government. Think about that. This is your conservative attorney general, who I guarantee you wants to be governor, because attorney general quite often becomes governor,
Yep.
and he's Mr. Conservative, but he's out there right at the tit of the federal government bringing in those dollars. How much of your budget, Mr. Attorney General, comes from the federal government? At least 2/3 of it.
So what they're saying is all we're doing is they change the way they talk about it. They say the children have a need for support, and therefore we're protecting that need. Well, they didn't have the need for support until you got involved, and then you stripped the other parent of their ability to care for that child directly. And some people say, well, they weren't caring for them directly in the first place. Well, maybe that's why they had to come to the court, because maybe the other parent was blocking them because your statutes entice them to block them because you will give them this benefit. I'm sorry, I'm getting
And by
passionate.
the way, Mr. Attorney General, you said strict scrutiny applies. The number one thing in strict scrutiny, which you conveniently left out of your opinion, is that the burden of proof shifts. That parent does not have to prove that they provided for their child. You, Mr. Attorney General, have to prove that they did not. That is the number one change when we deal with fundamental rights at any level of enhanced scrutiny, is that the state carries the burden. And you know what, these family law judges, you'll find case after case after case where these judges say we can presume our statutes are constitutional when they infringe fundamental rights.
But
you know what the Supreme Court of this state and the United States says? No, you cannot. Absolutely, you cannot presume your statutes to be constitutional.
But you know, the legislators, they had presentations from the retired judge and the Attorney General's office, and guess what they complained about? we don't like this law or that law or this bill. It's not a law, it's a proposed bill, because it shifts the burden. They actually complained about that. So they know that the burden is supposed to be shifted. They don't want it.
No, it
because
takes away
it
their
makes it
power.
harder. Right. They can't just go and take orders to the judge and say, sign these, because the burden then would be on them
It's on the state
to show that
actor.
it was necessary
And the state
to
actor
serve
is the
a
judge.
state's purpose.
Think about this for a minute. They say this is a private suit between individual parties, right? So the only state actor in the room is the judge. Who carries the burden of proof in that case? The judge, the state actor. That's what our newest book is all about.
Okay.
You don't have that one yet.
So you guys agree with me that the family is under attack,
Absolutely.
is endangered, actually.
Yeah.
They talk about global warming. Been talking about the family.
How many shootings did you see just in Texas alone? One was on the actual police department. How miserable does this, now I know some of the people, they say, okay, they had family mental health issues, so I'm not justifying anyone who uses violence, but what I am saying is that if you have a mentally ill person, do you want to go and put them under more stress? Do you want to attack them more through the court? How safe is that?
And think about this.
So they're endangering all of us when they do this.
Two parents are contemplating divorce.
Everyone
and they're
should be
told
angry
that
about
both
what
of you
they
are going
do.
to have equal time and equal rights to your child. And you're not going to go into a battle where one of you wins and one of you loses. You're not going to get to lord it over the other person. You're still going to have to work these details out and raise this child where both of you have full and equal rights. What does that do to the divorce equation? You start thinking and say, wait a minute,
we need to take the battle aspect out.
But
I want to thank you guys for being on my show this evening. I enjoyed it. I learned a little bit, a lot as a matter of fact. But I've got to have you guys back again if you're ever in the area.
Thank you very
would
much.
love it.
We enjoyed it.
Thank
You should, okay, thank you.
Thank you, Mike.
Thanks, brother.